Our last case of the afternoon is People versus Wimberly. Good afternoon. This is a mini oral argument on the application. You each have 15 minutes. You have 2 minutes of a free fire zone that you may waive, and you have time for rebuttal, but we ask that you keep track of your own time.
Thank you, Your Honor. Good afternoon, Your Honors. Angeles Manassas, along with co-counsel Gabrielle Barber for Jeffrey Wimberly in the State Appellate Defender Office. Jeffrey Wimberly will die in prison after being resentenced consecutively based on an ex post facto violation, when the trial court did not have subject matter jurisdiction to resentence him because Mr. Wimberly's time to file an application for leave to appeal with this court had not yet elapsed. Therefore, this court should remand Mr. Wimberly's case for resentencing. I waive my remaining free fire zone. Imposing consecutive sentences under MCL 750.520B in Mr. Wimberly's case violates the ex post facto clauses of both the United States and the Michigan constitutions, because the statute as amended is designed to increase the punishment for criminal sexual conduct. Mr. Wimberly's offenses occurred in 2002, 4 years before this amendment occurred, and it allowed for consecutive sentences to be imposed for any other criminal transaction arising from the same transaction. This is a discretionary power by the trial court. It is not required by the statute. Thus, this ex post facto violation...
Because you jumped right to the ex post facto, I'll just ask you, what is your response today to the prosecution's position on preservation of this issue?
This court has time and again ordered briefing on questions that had not necessarily been before it, either in the Court of Appeals brief that preceded this or the application for leave to appeal. This court does have the jurisdiction to order us to answer those questions, and if they find them persuasive, then to remand or to rule on them, and so I disagree with that. Also, the prosecution's argument makes much to do of that, but does not actually address the merits of this argument, and so there really is no response to the fact that this is an ex post facto violation.
If we think, agree with you that the trial court lacks subject matter jurisdiction under Washington, can we even get to ex post facto?
You would not have to, Your Honor. If this court did find that this is a straightforward application of Washington, as it should, and that the trial court lacked subject matter jurisdiction to resentence Mr. Wimberly, it does not have to reach that ex post facto violation issue, but does not want to.
But if we didn't, then we could and probably should order supplemental briefing on the ex post facto.
Absolutely. Both errors happened in this court. The trial court lacked that subject matter jurisdiction, and this was an ex post facto violation, which meant that the trial court was resentencing Mr. Wimberly based on a mistake of law. And Michigan courts have held time and time again that the remedy for sentencing someone to an invalid sentence due to a mistake of law is resentencing. So resentencing is the appropriate remedy here because the trial court used the perceived availability of consecutive sentencing under the statute to increase Mr. Wimberly's individual punishment for his CSE offenses. It is virtually impossible here to separate the distinction between where the trial court imposed consecutive sentencing because it wanted to impose a long sentence upon Mr. Wimberly versus to sentence him consecutively. Resentencing is necessary so that the court can exercise sentencing discretion through the appropriate mechanisms. And so Mr. Wimberly can have a full and fair opportunity at resentencing with all of the correct information. The court can have all of the correct information before it, not be operating under a mistake of law, and therefore have to fashion a sentence for Mr. Wimberly that is proportionate to him, his offenses, and is also, should the court choose to impose a departure, that departure under Smith is proportionate to Mr. Wimberly. If this court were to impose a rule that ex post facto violations such as this one should be remedied by resentencing, it would provide the courts with clarity. Because up until now, different remedies have been applied by this court and the Court of Appeals to address issues of improper consecutive sentencing. The trial court here didn't clearly indicate why a 78-year aggregate sentence on the minimum was particularly proportionate to Mr. Wimberly or his offenses. And so, again, resentencing would give the opportunity for the trial court to consider, to not operate under a mistake of law, to consider all of the information relevant to Mr. Wimberly as an individual, particularly given that he was 18 years old at the time of this offense, and all of the correct information and mitigating circumstances it needs to fashion a proportionate sentence for Mr.
And there's a
Wimberly.
risk, though, as well, to having a trial court with resentencing, an adverse risk to your client as well, perhaps.
Yes, Your Honor, that risk is always there. A court can decide to,
Saying, well, they're not consecutive, I thought they were, and adjust the sentence to make, and maybe that raises other issues, maybe it doesn't, it might be back here in front of us again. But if that were the case, but the resentencing there's a inherent risk sort of on both sides.
That's true. While there is an inherent risk, if we take Mr. Wimberly's case in particular, for example, the top of his guidelines equated to 39 years. So if the judge were to impose what is equivalent to the same sentence again, AKA a 78-year minimum sentence, that would still have to pass muster under Milborn, under Snow, and under Smith. So the court would have to justify why a 39-year departure from the top of Mr. Wimberly's guidelines is proportionate to him, not just the sentence overall. And so it's, they would have to pass muster in the appellate courts under those standards. Finally, Your Honors, again, the court lacked subject matter jurisdiction to resentence Mr. Wimberly before his deadline to file an application for leave to appeal had elapsed. Only 14 days had elapsed here since the Court of Appeals opinion. Mr. Wimberly did not even have the opportunity, whether he was represented by counsel or whether he was pro per, to file an application yet at that point. In fact, he still would have been within the jurisdiction to file a motion for reconsideration of the Court of Appeals opinion. Yet still he was resentenced 14 days later. This is a straightforward application of Washington, and so this court should remand.
So let me just ask on that point. Is it your position that from the time the Court of Appeals remanded to the trial court until the deadline for an application to file in this court is filed, that the trial court lacks subject matter jurisdiction?
It's our argument that the trial court lacks subject matter jurisdiction, for that 56 days until the Court of Appeals judgment became final.
Would
And then
any court have subject matter jurisdiction during that period?
yes, the appellate courts. The appellate courts would. Technically,
Which one? Our court or the Court of Appeals?
at the particular time that Mr. Wimberly had the 14 days, technically the Court of Appeals would have still had jurisdiction because he could have filed a motion for reconsideration of the Court of Appeals opinion.
After the reconsideration period in the Court of Appeals has passed, does that pass subject matter jurisdiction to the Supreme Court?
Yes. And then technically it has not, because, well, and also given that Mr. Wimberly filed 2 notices of intent to this court under the administrative order indicating that he did intend to appeal this decision, yet still was resentenced anyway. The court rule is very clear, the statute, the Constitution, and this court's case law is very clear that jurisdiction does not revest in the circuit court until that time has elapsed. And so the circuit court did not have jurisdiction here.
So if we agree with you on that sequence of how subject matter jurisdiction is decided, could a party waive the application period in order to return the case to the trial court and move more quickly?
Yes. And they also could have filed a motion to kind of resentence while that application process was happening. I myself have done that in appeal cases where I do intend to file an application.
How can you do that if the court doesn't have subject matter jurisdiction? The parties can't confer subject matter jurisdiction, can they?
Thank you.
Sorry.
No, it's okay. Handoff. Baton handed.
So in your world, the parties can't confer subject matter jurisdiction despite the fact that the court has held that to the opposite, to the contrary, for hundreds of years?
Can you please clarify your question?
You just said the parties can waive the appeal period, that this court has subject matter jurisdiction even though an application hasn't been filed, but the parties by private agreement can confer subject matter jurisdiction on the trial court to proceed.
Not by private agreement, Your Honor, by the proper mechanisms. Should they file a motion, for example, if the prosecutor does not intend to appeal the decision, if they lose in the Court of Appeals, then you can proceed to resentencing if the parties have agreed that the appeal should be dismissed from that point on. Also, you can file a motion to allow for resentencing while that application process is playing out if both the party files the appropriate motion and it plays out in the courts. You cannot just decide that by private agreement. And
that sounds like a sensible way to proceed, but I don't see how that's compatible with your argument that this court has automatically vests with subject matter jurisdiction for the remainder of the appeal period until that period expires.
Because here we did not have a situation where the parties agreed, we're not, Mr. Wimberly did not think, oh, I'm not appealing this decision from the Court of Appeals, I'm just going to proceed to resentencing, let's file a motion, or let's have an agreement with the parties in court to say, we're not going forward with this appeal, let's resentence. Here, in fact, Mr. Wimberly was very clear that he intended to appeal this decision, and he was still well within the time limit to do so. If there are no remaining questions at this time, I will reserve my remaining time for rebuttal.
Thank you.
Good afternoon, Your Honors. May it please the Court, Elizabeth Matthews on behalf of the people, plaintiff appellee in this matter. I'd like to briefly touch upon 2 points. My first point, the people do not agree that resentencing is called for in this case on the basis of an alleged ex post facto violation. As stated by the trial court, defendant was not sentenced in a vacuum, and courts can and should consider the person who stands before them in their entirety. Defendant never raised this issue, and this court has never directly held that retro application of the consecutive sentencing statute is improper for ex post facto purposes. As this is an issue of first impression, we submit that it is not for the people to decide that an ex post facto violation occurred here. However, if this court is inclined to make that determination, we submit that the appropriate remedy is to amend the judgment of sentence to reflect concurrent sentencing. There's precedent for amending the judgment of sentence in Michigan case law and statutes, where, as here, the trial court sentencing was proper. There's also precedent in previous cases such as People versus Porter, where the prosecution conceded an ex post facto violation, and this court ordered an amended judgment of sentence. My second point, we are also asking that leave is denied as to the subject matter jurisdiction issue. The circuit court prematurely conducted its resentencing before defendant's time to file his appeal to this court expired. But that resentencing was separate from any appeal involving defendant's convictions. So in other words, there wasn't a danger of 2 courts considering the same subject at the same time. And the people submit that this wasn't an error in subject matter jurisdiction. This was at most a procedural error in violation of an automatic stay set forth by the Michigan court rules. So we propose that it is therefore subject to a harmless error analysis, and I'd be happy to answer any questions.
If we remanded for full resentencing on the individual sentence, opposing counsel has said that there's a risk there, that the sentence could be longer. Does that benefit the prosecution, the defendant? Is it neutral?
I think it could lead to endless appeals, quite frankly, and the victim's family has already been through a lot in this matter. There's been a lot of appeals already. So if this court allows full resentencing, it'll be in pre-sentence posture, and every aspect of the sentence is before the judge de novo to be rescored.
Is it your position that Washington is distinguishable here, or that Washington should be overruled?
Well, in a perfect world, we would like Washington to be overruled. I don't necessarily agree with the rules set forth in Washington, but I think there's some wiggle room in its framework. Other states that follow a similar rule allow for what's called a partial divestiture of jurisdiction over matters that don't affect the appeal, and that allows for greater judicial efficiency in instances like here where the same matter isn't set before 2 courts at the same time. So that's what happened here. Defendant's resentencing would not have affected any appeal he may have filed of his convictions.
You indicated the ex post facto question wasn't preserved, but that aside, do you disagree with the merits on that argument?
Well, yes. First, as you said, we don't agree that the court needs to reach the issue based on the party presentation principle. But second, whether or not this statute was punishment for ex post facto purposes is an issue of first impression before this court. So it's never been exactly decided whether or not this particular statute is punishment for ex post facto purposes. So we don't agree that it's for the people to decide necessarily. And there's also been other cases, like the De Leon case, that say although consecutive sentencing under that statute lengthens the total period of imprisonment, it does not increase the penalty for any specific purpose. So as it's an issue of first impression, we don't believe it's necessarily for the people to determine whether or not it's punishment and concede on that issue.
But if we go down that road, you'd say just remand it and vacate one of the sentences, don't send it back for resentencing.
Yes, so if this court does determine that an ex post facto violation occurred in your discretion, then we submit it is appropriate to amend the judgment of sentence, but we don't agree that that's called for here. Are there any other questions? Thank you, Your Honors.
Thank you.
Just two brief points on rebuttal, Your Honors. First of all, this is, there is no wiggle room in terms of this case and Washington when it comes to subject matter jurisdiction. This is a straightforward application of Washington. In Washington, the individual was resentenced while the appellate court still had jurisdiction over his case. The jurisdiction had not yet vested back in the circuit court, and that is the same case here. And in Washington, when this court relied on George and its reasoning as well, its prior case, it held that resentencing was the appropriate remedy in that situation. It's distinguishable from, as the prosecution argues, issues of, standard jurisdiction, such as that in Luscombe, where, you don't have like a file that's returned to the circuit court, and then you file, that doesn't affect jurisdiction, subject matter jurisdiction. That only affects kind of your standard jurisdiction, and that would lead to a harmless error analysis, but here we have a straightforward application of Washington. Also, I would disagree as to the ex post facto violation issue that this is a matter of first impression for the court, because this court has dealt with the imposition of consecutive sentences in an ex post facto way for offenses that predate the amendment of the statute in both Porter and Klakowski. The court did not have to rule in those cases that it was specifically an ex post facto violation because the prosecutor conceded error in both issues, but it is acknowledged in both orders that this was error and that it should be remedied.
Counsel, how do you respond to Ms. Matthews' point that the appeal was a different issue, and so Washington can be distinguished?
I would disagree, because again, this is a straightforward head-on application of Washington. Here, even though, if Mr. Wimberly, once he appealed his convictions to the Supreme Court, had this court decided to do something with that, had it decided to send it back for a new trial, or whatever the case may be, there would be no need to resentence Mr. Wimberly. A resentencing wouldn't happen because his case would get sent back for a new trial or something similar under those circumstances. So here, this is exactly what Washington laid out. You cannot resentence someone until that time has passed for them to appeal the decision, and that is what Mr. Wimberly very clearly intended to do here.
Washington is factually distinguishable because there an application was pending, and here there was no application pending at the time of resentencing. Do I have that correct?
That part is correct, Your Honor. However, this court...
So this would be an extension of Washington, and I'm trying hard to understand your rule. Your rule would be that the lower courts lose jurisdiction not just when an application is filed, but they lose it automatically after the rehearing period until the end of the appeal period has run. Is that right?
Yes, and that's under this court's precedent in George.
Automatically divested unless the parties decide that they'd rather have jurisdiction in a different court, and then they can file a motion, and then the jurisdiction travels wherever the parties would like it to go. Is that your world, how that would operate?
No, Your Honor. It would be, it's not simply if the parties decide that they want jurisdiction in a different court. Here, we have a situation where Mr. Wimberly received an opinion from the Court of Appeals. He indicated his intent, per this court's administrative order, to appeal that, and his time to do so under the order and under the court rule had not yet elapsed. This is not a situation where, for example, the parties may decide, the losing party decides, I don't want to appeal this.
Okay, so he doesn't file an application, he indicates his intent to file an application.
Yes.
That's enough for jurisdiction to be automatically vested in the Supreme Court, because the party indicates an intent to file an application. Do I understand that right? That's the rule?
Yes, for two reasons. And in this case, because jurisdiction had not yet vested back in the circuit court under George, and because this court's administrative order was very clear during the pandemic that if someone was filing pro per, as Mr. Wimberly did, that a notice of intent would toll that filing period. And so Mr. Wimberly had both situations. So even if the notice of intent had not yet happened, this is still within his purview of time to file an application for leave to appeal with this court.
So just to clarify your response, the notice of intent was not required as long as Mr. Wimberly was still within his time period to appeal in our court.
Yes, but that notice of intent does add another layer because everyone was on notice.
But in different circumstances, your client gets a Court of Appeals opinion, and they're intending on appealing, and then the trial court sets something for the very next week to resentence. Your argument is the same today.
Correct.
Yeah.
Do you have any legal authority for your assertion that the parties can file a motion to proceed with the case, even though jurisdiction is vested in a different court?
I do know that the court rules allow that. I don't have the court rules cited off the top of my head, but I'm happy to provide that to the
Where
court
would the
supplemental.
parties file that? So in that situation that I just described, would they file it here? Would they file it with the Court of Appeals, like we're final, that we're not going to appeal?
The Court of Appeals at
Court
that
of
point.
Appeals.
Yes.
Whichever court has jurisdiction of the case at the time.
Yes.
Okay. You're not saying that they could go to the trial court and file something there to get subject matter jurisdiction back from the trial court. You're saying it's with the court that currently has jurisdiction.
That's right, Your Honor.
Okay, thank you.
Thank you.
Any other questions? Okay, thank you both. The case will be submitted, and the court will stand in recess until tomorrow morning at 9:30.